Bowie and Officer Scott, would you please raise your right hand? Mr. Bowie. Do you solemnly swear that you will keep every person sworn in this jury in some private area and that you will not allow any person to speak to them until they use the jury in this case? Thank you. All right, ladies and gentlemen of the jury, you have been selected as the jury in this case, and as you know, this is a criminal case. And to assist you in better understanding your functions and duties, I will tell you how the case will proceed. You are the sole judges of the facts, and your determination of the facts is to be based solely upon the evidence submitted during the course of the trial. When I use the term evidence, I mean the testimony of witnesses who will testify and any exhibits which may be marked into evidence and which will be taken into the jury room for your review at the end of the case. The first order of business will be the prosecutor's opening statement. In the opening statement, the prosecutor will present the state's contentions and will outline what he expects to prove. Following that, the defense counsel will make an opening statement. What is said in an opening statement is not evidence. The evidence will come from the witnesses who will testify and from whatever documents or tangible items that are received in evidence. During the trial, the attorneys may make objections as evidence is offered, or they may address motions to make. They have a right and indeed a duty to make objections and motions when it seems to them to be proper to do so. I have a duty to rule upon any objection and motion based upon the law. If you hear me say that an objection is overruled, that means I'm ruling against the attorney making the objection. If I say that an objection is sustained, I am ruling in favor of the attorney making the objection. Anything excluded by me is not evidence and must not be considered by you in your deliberations. Sometimes these evidence questions or legal questions will be heard in your presence in open court, other times at sidebar, or you may be excused and go into the jury room so that we can discuss the issue in open court. I realize that being confined in the jury room for any length of time is not very pleasant, but I ask your indulgence and your patience. I'm sure that you realize that these legal arguments must be heard outside of your presence. You should not conclude that because I rule one way or another that I have any feelings about the outcome of this case. I do not. But even if I did, you would have to disregard them since you will be the sole judges of the facts. During the trial, from time to time, there shall be recesses. During any of those recesses, I direct you not to discuss the case amongst yourselves. And when we recess overnight, you must not discuss the case or the testimony with any members of your family or any other persons, or provide an account of your juror service to others, including through any electronic means. During jury selection, it would be improper for any outside influence to intrude upon your thinking. If anyone should attempt to discuss this case with you, you should report that to me or my staff immediately. During jury selection, you were asked and you responded to a series of questions from the court and from counsel. If during the course of the trial, you realize that you may have made a misstatement or omission during your responses, or if circumstances arise that could change or alter the answers you gave, do not discuss those matters with your fellow jurors. Rather, you should tell the court officer who will notify me at once. During the trial, you are not to speak to or associate with any of the attorneys, the witnesses, or the defendant, Douglas Lewis, nor are they permitted to speak or associate with you. This separation should not be regarded as rudeness, but rather as a proper precaution to ensure fairness to both sides. If anyone connected with this case or any other person approaches you or attempts to influence you in any way, do not discuss it with the other jurors. Simply tell the sheriff's officers, and I will be notified immediately. Your deliberations must be based solely on the testimony and exhibits admitted to evidence, without any outside influence or opinions of relatives or friends. Additionally, do not read any news stories or articles in print, on the internet, or any blog about this case. I do not know if there will be any newspaper or media coverage of this trial, but you are instructed to completely avoid reading, viewing, or listening to any newspaper or media account, or listening to anyone else discuss them. Additionally, I must instruct you not to read any newspaper articles or search for or research information relating to the case, including any participants in the trial, such as the parties, the witnesses, the lawyers, the judge, or court personnel through any means, including electronic means. This strict prohibition against outside research and communication applies not only to print and reference materials, but also to the internet and any other electronic medium. You are not to seek any additional information on the subject matter of this case, the laws in any way related to this case, or any other factual or legal matter that has any connection to this case. Do not visit or view any place discussed in this case, or do not use internet maps or Google Earth or any other programs or device to search for or view any place discussed in the testimony. I'm sure that you can understand why this instruction is so important. Information from sources outside of the courtroom is not evidence. It's often based upon second and third-hand information, is purely hearsay, is not always accurate, and is not subject to examination by the attorneys. A juror's improper use of outside technology can threaten the very fairness of our system of justice and could result in the court having to start the trial all over, wasting the courts, the parties, and your valuable time and resources. In the event that such outside information comes to your attention, it is important that you tell me you're a member of my staff so I can determine what further action is necessary to ensure the fairness of the trial. The court and the parties rely upon your good faith and the fact that you've been sworn to comply with the instructions of the court so that both sides may receive a fair trial. Because this instruction is so important, it is my duty to remind you of it at the end of each day's proceedings. Since you are the sole judges of the facts, you must pay close attention to the testimony. It is important that you carry with you to the jury room not only a clear recollection of what the testimony was, but also a recollection of the manner in which it was given. It will be your duty to pay careful attention to all of the testimony. If you are unable to hear a witness, I ask that you indicate this to me by raising your hand so that I may instruct the witness to speak louder and or more clearly. As jurors, you will be required to pass upon all of the questions of fact, including the credibility or believability of the witnesses. You are not permitted to visit the scene of the alleged incident, do your own research, or otherwise conduct your own investigation. Your verdict must be based solely on the evidence introduced in this courtroom. Jurors are not permitted to take notes. Experience has shown that note-taking is distracting and it is better to depend upon combined recollections of all the jurors than upon notes taken by one or more of them. Now, at the conclusion of the testimony, the attorneys will speak to you once again in summation. At that time, they will present to you their final arguments based upon their respective recollections of the evidence. Again, this is not evidence, but their recollection as to the evidence. It is your recollection as to the evidence presented that is controlling. Following summation, you will receive your final instructions on the law from me, and you will then retire to consider your verdict. You are not to form or express an opinion on this case, but are to keep an open mind until you have heard all the testimony, have heard summations, have had the benefits of my instructions as to the applicable law, and have been instructed to begin your deliberations. It is your duty to weigh the evidence calmly and without bias, passion, or prejudice, or sympathy, and to decide the issues upon the merits. You as jurors should find your facts from the evidence adduced during the trial. Evidence may be either direct or circumstantial. Direct evidence means evidence that directly proves a fact, without an inference, and which in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that facts be proved by direct evidence. They may be proved by direct evidence or circumstantial evidence, or by a combination of direct and circumstantial evidence. Both direct and circumstantial evidence are acceptable as a means of proof. Indeed, in many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. In any event, both circumstantial and direct evidence should be scrutinized and evaluated carefully. A conviction may be based on direct evidence alone, circumstantial evidence alone, a combination of direct evidence and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. Conversely, if direct or circumstantial evidence gives rise to a reasonable doubt in your mind as to the defendant's guilt, then the defendant must be found not guilty. I'm going to give you an illustration to talk about the differences between direct evidence and circumstantial evidence. Now, the problem is proving that it snowed during the night. Direct evidence would be testimony indicating that the witness observed snow falling during the night. Circumstantial evidence would be testimony indicating that there was no snow on the ground before the witness went to sleep, and that when he or she arose in the morning, it was not snowing, but the ground was snow covered. The former example directly goes to prove that fact that snow fell during the night, while the latter establishes facts from which the inference that it snowed during the night can be drawn. As judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into consideration the appearance and demeanor of the witness, the manner in which he or she may testify, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning their judgment, their understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness testifies, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statements, and any and all other matters in the evidence would serve to support or discredit his or her testimony to you. During your deliberations, you may ask what is more reasonable, the more probable, or more logical version. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. Two or more persons witnessing an incident may see it or hear it differently. An innocent misrecollection, like failure of recollection, is not an uncommon experience in weighing the effect of a discrepancy. Consider whether it pertains to a matter of importance or an unimportant detail, and whether the discrepancy results from innocent error or willful falsehood. Douglas Lewis stands before you on an indictment found by the grand jury charging him with committing the crimes of murder, conspiracy to commit murder, possession of a weapon for an unlawful purpose, unlawful possession of a weapon, and aggravated assault. The indictment is not evidence of the defendant's guilt on the charge. The indictment is a step in the procedure to bring the matter before the court and the jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty on the charges stated in it. The defendant has pleaded not guilty to the charges. The defendant on trial is presumed to be innocent, and unless each and every essential element of the offenses charged are proved beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of the charge beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. It is not the obligation or the duty of the defendant in a criminal case to prove his innocence or offer any proof relating to his innocence. The prosecution must prove his case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Now, some of you have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proofs must be more powerful than that. It must be proof beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your mind about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. You will note that a jury of 14 has been drawn in this case. At the conclusion of all of the evidence and the charge of the court, there will be a random selection in which 2 jurors will be selected to act as alternates. The 12 remaining jurors will then deliberate and return a verdict. At this point, we do not know who the alternates will be, and whether or not their services will be utilized. Therefore, I direct that all jurors should pay equal attention to the evidence as it is presented and to the court's rulings which are applicable to this case. All right, ladies and gentlemen, we are now prepared for opening statements, and we will start with the state.
Thank you, Your Honor.